In 2008, Russian tax lawyer Sergei Magnitsky exposed corruption amongst Russian officials. He was arrested, beaten, and died after a year in custody. This case led the US to first introduce the Sergei Magnitsky Rule of Law Accountability Act in 2012, and later the Global Magnitsky Human Rights Accountability Act of 2016, a global thematic sanctions programme. The UK, EU, Canada and many others have since adopted similar thematic sanctions, intended to punish severe human rights violations and grand corruption, highlighting a shared goal of tackling such issues. However, there is a notable divergence with regards to who or what each region is targeting. The US, EU and UK have 749 records in total listed under human rights and corruption sanctions programs. Roughly, only 3% of entries are listed by 2 of the 3 regulators, and less than 1% of entries are listed by all 3. The list size of the US is also 4 times larger than that of the UK and EU combined. But why are there such discrepancies? It's chiefly down to scope and timing. Not all the programmes are targeting the same issues. The US and UK focus on both human rights violations and corruption. The EU only covers human rights abuses. Plus, the US began designations in 2017, whereas the UK and the EU didn't introduce their programmes until 3 or 4 years later. This divergence can make it difficult for businesses to effectively identify and manage sanctions risk. And so, organisations must get proactive by not only screening against relevant sanctions lists, but by also carefully considering enforcement information and negative news to flag entities who may be connected to human rights violations or corruption. To learn more, read our latest article.